You're here before the pardon board this morning requesting a commutation of your sentence. You were sentenced on July 7th, 2004 to life for a second-degree murder conviction out of Ouachita Parish. Is that information correct?
Yes, ma'am.
Okay, I'm going to turn it over to Mr. Roche.
Thank you, Madam Chairman. Warden Boutte, can you adjust the camera so that we can see a little bit more of Ms. Cameron? Thank you. Perfect. Good morning, Ms. Cameron. How are you?
I'm well. How are you, sir?
Good. As the chairman said, my name is Alvin Roche, and I'm going to do a presentation, and then we're going to ask you some questions. If any of the information is incorrect, would you please correct me, okay?
Yes, sir.
Madam Chairman, we have Mary Cameron, DOC number 481229. She's currently 64 years old. And at the time of the offense, she was 45. She's been incarcerated for 18 years and 9 months. She is seeking a recommendation for a commutation of sentence for the offense of second-degree murder in the beating death of her 7-year-old stepson in 2002. And as I said before, this was only 18 and a half years ago. She was found guilty by a jury of her peers of second-degree murder on April 22nd, 2004, and was sentenced to life without benefits on July 7th, 2004, just 3 days after her victim would have celebrated his 10th birthday. She is a first felony offender. As I said before, she's been incarcerated a little less than 19 years. Opposition in this case comes from the entire legal community. The sentencing judge, Judge Wendell Manning of the 4th JDC, is strongly opposed. The district attorney in Ouachita Parish is strongly opposed, and he submitted a statement. He is strongly opposed to any clemency, and I quote, "This was a brutal beating death of a child," unquote. The sheriff of Ouachita Parish is strongly opposed. The chief of police of Monroe, Louisiana is opposed, and the chief of police of West Monroe is opposed. There's also very strong victim opposition. The father of the victim, Ms. Walter Cameron Sr., is adamantly opposed, and he submitted a statement saying, "She doesn't need to get out. My son is gone. It puts my life in danger if she's released because I've since divorced her. There's something wrong with her mind." The coroner report said that my son had bruises all over his body from the offender kicking my son. I'm at peace now, and I won't be at peace if she's released. That was a statement from the father of the victim. Ms. Cameron, you're 64 years old now. What is different about Mary Cameron at 64 than Mary Cameron at 45 when she brutally beat a 7-year-old to death?
I'm not the same as I was at that time. I have changed a lot. At LCIW, I got into programs to better myself, to educate myself, to change my thinking pattern. I took up anger management that helped me a lot. I got into a lot of classes. I worked in the community with younger people. I have learned how to control my temper. I have engaged in educational projects. I have been into VOTEC classes, and I'm currently working on my GED. I've learned a lot about cancer because I'm a cancer survivor. I want to give more knowledge that is think before action. I try to instill young women at LCIW not to make poor choices that I did. I try to help people with education because I need my education, and I've learned the value of helping people. And I want to give back, even in LCIW community. I try to give back to the younger people. I even use my situation so they don't make poor choices like I did.
Thank you, ma'am. Ms. Cameron, what I understand from what my information is giving me that you were the homeroom mother for your stepson's classroom. Is that correct?
Yes, sir. I tried to help out at school too.
Okay, why was it necessary for you to be at your son's class almost every day? And the teacher says sometimes you were there all day and you interrupted her teaching process.
And some days, little Walter wouldn't want to go to school. And I said, well, I'll take you to school. He said, I don't want you to leave me. I said, well, I'll stay if this will make you happy. And I referred that to his father too.
Okay, now tell me why it was necessary to have a conversation with the teacher about Lil Walter's behavior at home.
Because his behavior changed when he got into a different grade. And I explained to his behavior had to change because he didn't want to do his homework and stuff. And I was trying to figure out what was going on with me and him and why he didn't want to do the extra homework that was assigned to him.
I can understand you telling about homework, but I understand some of those conversations you had with his teacher were of a confidential nature and it had nothing to do with school.
I don't remember confidential.
Well, there was
I
something
remember.
that Lil Walter was doing that he wasn't supposed to be doing, and you related that to the teacher.
I don't remember that I talked to his father about it.
But it had to do of a sexual nature, and I don't understand why you would discuss something like that with the teacher. Okay, let's continue. Now, you were home with your son most evenings, right?
Beg pardon, I didn't hear you correctly.
You were home with your son most evenings after school, am I correct?
Picking up from school every
Yes. And what would happen every evening when Walter Sr. would come in from work?
Little Walter usually would meet his father at the car and bring in groceries and stuff. And he would do his homework.
Well,
before his father would come in and stuff like that.
My information says that little Walter would greet his father by jumping all over him, and then they would spend some time together, father and son time, each and every day. Is that correct?
He spent some time with little Walter, yes, sir.
Okay,
When
so
he wasn't at work, it was family time.
okay, but
We had family time together.
okay, but from my understanding is that Walter Sr. lost a wife and Walter Sr. lost a mother years before your relationship started. Is that correct?
Yes, sir.
So Walter Jr. was a very special person as far as Walter Sr. was concerned, and he spent a lot of time with him. Is that correct?
Yes, sir. Little Walter was very special.
Okay. And why was it necessary to physically abuse little Walter to the point where he was bruised, broken, and eventually caused his death?
Little Walter didn't want to do his homework, and he didn't want to beg us, but just go ahead and do your homework and stuff. And when this incident happened, his father was there. Little Walter, his father took him to bed. And I was telling him the problem we was having. And we was in the room discussing something. I heard some noises. I said, let's go check on him.
Ms. Cameron, that is sufficient, okay? Let's go on to another part of the presentation. A tiger instrument was performed on Ms. Cameron in 2019, and it came out as a low risk. But the tiger instrument that was performed in 2020 showed a different story. And let me get to that. This was performed in January of 2020. And in the areas of transportation, she scored a low risk. In the areas of antisocial thinking and peer, she had a moderate risk. Substance abuse, she had a moderate risk. Health and depression, she had a moderate risk. Education, a very high risk. Employment, high risk. Her composite score in 2020, which was the last tiger done, has a composite score of a moderate risk, which tells us that she has a moderate chance of reoffending. To go over her progress report, she's in minimum custody. She has a moderate risk assessment score. She's completed re-entry in 2018, and she's currently enrolled in GED classes. Tell me how the GED classes are going.
My scores have come, pardon me. My scores have came up. I'm at a JSEP level, getting ready to prepare for JSEP to go to GED.
Right, so you really hadn't started the GED program yet?
No, sir.
You're going to take the examination?
I'm getting ready to do JSEP to take the examination for GED.
Okay. And that's coming within a couple of months?
Yes, sir. Yes, sir. I've been trying to get my GED, but I got sick in 2009 and I had surgery. I had colon cancer and I'm getting back in, I had to back enroll.
Great, outstanding. Ms. Cameron is a member of the Lifers Association. She has a good institutional record, and she has only one write-up in almost 19 years of incarceration. That was in 2009, some 12 years ago, and it was a Class A write-up for disobedience. Have you had any disciplinary write-ups since that?
No, sir.
Outstanding disciplinary record, Ms. Cameron.
Thank you,
And
sir.
I see why you finished anger management in December of 2020, only about 2 months ago.
Yes, sir.
What did you get out of anger management?
Anger management made me look at myself and evaluate myself and to come to grips with things that I need to control, that I need to take responsibility for a situation and control my anger. And if a problem comes up, not to jump the gun, to find an outlet or someone to talk to about what's going on. I have people here that I can talk with, and even at home, I have family members that I tell what I'm going through. So I won't get to that point of losing self-control because I'm in control.
Thank you, ma'am. As a ACER instrument was performed, and the ACER instrument is to gauge any negative or violent event that happened during an offender's childhood that would have any bearing on her criminal activity as an adult. Your ACER score came back at 0, saying that you had no negative, no violent, no sexual activity as a child that would cause mitigating circumstances or explain your criminal activity as an adult. The ACER score 0 is the best score that an offender can achieve, saying that there were no negative in her early childhood that would cause criminal activity. You have an approved residency plan. You'll be staying with Ms. Ernestine
Yes,
in
sir.
Wisner, Louisiana.
Yes, sir.
Who is Ms.
Ernestine Augustin,
Yes.
that's my baby sister. She's staying in my mother's house.
So basically, you stay with Ms. Augustin in Wisner, Louisiana,
Yes, sir.
and you have approved employment with Louisiana Pride, a catfishing process plant.
Yes, sir.
Okay. There's letters of support for your clemency from Sherry Sims, who I think is a current or former offender, who says that you helped her with our rehabilitation. You have a letter from Ms. Brenda Thornton, who is a long time. She says she's been knowing you for 40 years. She went to school and she lives in the same hometown, and she is in support of your clemency. You also have letters from your sisters and brothers, including Miss Ernestine Augustin. Warden Boutte, would you like to make any comments, remarks, or observations at this time?
There's literally nothing else that I can say about her behavior while she's here at LCRW. She posed no threat to others, herself, and anything that was basically, she was given the opportunity to participate in regards to her actual crime. I see it in her record. So other than that, I don't have any further comment.
Thank you, Warden. Madam Chairman, I do have a recommendation in this case, and I will share it with you and the other board members at the conclusion of this interview.
Thank you, Mr. Roche. Very, very thorough. Mr. Marabella? I'm sorry, you're on mute, sir.
Thank you, Madam Chairman. Mr. Roche's presentation and questions were very thorough. I have no questions. I'd like to listen to our speakers before I make a decision.
Thank you. Mr. Jones?
I like Mr. Beverly. I want to hear the rest of the speakers and hear from them before I make my recommendations. I may have a question from, I want to reserve my right to ask her a question after I hear from them.
Okay, good. Yes, sir. All right. So can we first hear, we'd like to hear from our guest. We'd first like to hear from Mr. McFarland. There you go. Yes, sir. Go ahead, Mr. McFarland.
Thank you
If you
so
would
much.
introduce yourself and tell us your relationship to the victim in this case.
My name is Bishop Rodney McFarland Sr. I'm the pastor of the Greater Free Baptist Church here in Monroe, Louisiana, and also the funeral director and embalmer for McFarland Funeral Company. I am the one that officiated the service and also was the one that picked up his remains and prepared him for burial. His father is a very close friend of mine, and I oppose this because when this incident happened, I had just been pastoring for 13 years and had been in business for 14 years at that point. I had never seen a case as bad as this case. The brutal beating that Miss Cameron put on this little child was unheard of, very disturbing. My children also was students at Swayze Elementary School. Everybody was traumatized when they heard of this brutal beating. The children, they needed ministers and others to come down and counsel with them during that period of time. And during even myself, it was very stressful for me in order to prepare his body, how beaten the child was. I do not recommend that you all would let her out. If justice was served, she have life in prison. And for someone to do a little child in that manner, and I am one that believe in forgiving. Yes, we forgive her of her action, but not to let her out back to do the same again. You cannot assure us that she will not go out and do this again. It was a horrible beating. And I don't know if the board has paperwork or copies of the autopsy report, but this was horrible. And again, I speak as the pastor that officiated over this young child, and also as the funeral director and the embalmer that prepared the young child. No, please do not release her. Thank you so much. God bless you.
Thank you, sir. We appreciate your input. We'd like to hear from Mr. Cameron. I'm sorry, so you're on mute. You have to unmute your microphone.
I'm trying to
There
get
you
myself together. It's hard to say anything. Because this just still on my mind. I shake it. I love my son so much. He was a miracle baby. And I got her to take care of my baby while I work. I pay all her bills. All you had to do was just take him to school and take care of him. And she couldn't do that. I guess I'm sorry. I just can't go no further. I can't. I thought she needs to tell like my baby not come back to me.
Yes, he's taking it pretty hard, but like I say, he's been struggling with it and been dealing with it for so long that she needs to stay where she at, because she took a part of him from him. She took that child. He was nothing but a child. like I say, we don't want her to get out there and do another child like this. But you'll be all right.
Thank y'all for listening.
Yes, sir. Miss Brenda, any comments? I'm sorry, you're muted. I can't tell if you, there you go.
No, I don't have any comment no more than we want her to stay in where she at.
All right, thank you, ma'am.
Because that baby's not able to enjoy his life. Why should she enjoy the rest of her life?
Yes, ma'am, thank you. We appreciate all participation. Ms. Cameron, we'd like to hear from you if you'd like to make a statement.
Why the regret? Words can't. Regret is not a strong enough word to say for the pain that I caused. I live with that every day. I love little Walter. I can't say,
Speak up.
I can't really say.
Do you wish to continue talking, Ms. Cameron?
Okay, Warden, does that conclude her statement?
Yes, it does.
Thank you, Warden Boutte. All right, we'll continue. Mr. Roche, I'll turn it back over to you.
Thank you, Madam Chairman. Ms. Cameron. Ms. Cameron, in my opinion, you have served it less than 19 years for the second-degree murder and the beating death of your stepson. Your stepson was entrusted to your care. 19 years is insufficient retribution. Plus, you have a composite Tiger score as moderate risk to reoffend. You have a moderate risk in antisocial thinking, substance abuse, mental health and depression, and a high risk in education and employment opportunities. The entire legal community is opposed to any clemency. The sentencing judge, the DA's office, the sheriff's office, the chief of police. The victim's family is adamantly opposed to any clemency. You should continue working on your GED and concentrate more in the area of community service for the rest of your incarceration. For all the above reasons, my recommendation is to deny your request.
Thank you, Mr. Roche. Mr. Marabella.
Ms. Cameron, you have done a lot of positive things while you've been in prison. And I certainly recognize that. Your crime was a very horrible crime. I'm concerned about some of the things that Mr. Roche brought out about your behavior initially when time was going on. I think that you need some more programming and perhaps some more counseling and therapy to be able to reach the point that I would be comfortable to vote to commute your sentence. But based upon all of the things that Mr. Roche has said, based upon the comments that have been made by all of the opposition in reviewing your record. It's going to be my vote today as well to deny your request for a commutation of your sentence.
Thank you. I'm sorry, I'm having some technical issues. Mr. Jones?
Yes, Madam Chairman, I concur with my colleagues. My vote today would be to deny also for the same reason that's been stated.
And I too, Miss Cameron, agree, especially with the additional program. I want to commend you on an excellent conduct record. You have done some really good things, but I think you just have some more work to do. So my vote today, because of the opposition that's expressed here today, is to deny your application. So today your application's been denied. Thanks everyone for your participation.
There's something just so tragic and so awful and so terrifying at the same time about this hearing. I don't think you need to have kids to feel that sense of, or all these emotions that I'm feeling. But when you do have a child at this age, 7 years old that I do, I have no compassion for her at all. And I really appreciate what the preacher had said. I really do. The bottom line, when Mr. O'Shea starts the interview and he goes, and I'm so happy that Mr. O'Shea had this, because the compassion that he was expressing during this interview for little Walter, the way that he would say that every time, little Walter. And you picture this little 7-year-old boy who lost his mother. This new woman comes into his life, and you can tell she is a demon. She is the stepmother that the fairy tale books warn us all about. He didn't have to read about Cinderella, which actually makes his situation look like a Hollywood ending. He's living in a world where his stepmother is not only beating him at home, but finding a way to sit in his classroom, to watch him in his classroom. How the system even allowed that is a different question. But if you can only imagine the fear that this little Walter, this little boy, is in when he can't even escape her in class. Where this demon is following him around everywhere he goes. You hear her explaining why it was that she was doing these things. And it's even all these years later, was it 19 years later at her parole interview? She says Walter wasn't doing what he was supposed to be doing. He wasn't doing his homework. So you beat him to death? So you followed him around and went and sat in his classroom? And then when she went to explain the story of how it all happened, Mr. O'Shea just cut her off. Didn't want to hear any of it. Oh, we put him to bed and then and he's okay, I've heard enough. To think that a woman remember, this is a commutation hearing. She's asking for the commutation board to make a recommendation to the governor to allow her to have a parole hearing because she's meant to serve life in prison. This hearing took place on January of 2021. We may see her again sometime soon for another commutation hearing. And I hope they never approve her. It's funny, the whole low risk score thing. Mr. Nasa says, it's interesting. In 2018, you had a low risk score. In 2020, 2 years later, it wasn't low. So it's like, huh, Mr. Nasa, you think maybe you're catching on? You think in the 2 years of prison she got worse, or maybe your little algorithm from your little PhDs over there, that maybe their algorithm is broken, maybe it never worked to begin with. To think that she even could be a moderate risk score and not a high risk score for antisocial thinking. She is a poster child for a sociopath. The crying that she was doing, I was paying close attention. I've watched it twice. We've seen many different type of fake cries. I think she was shedding real tears. It's hard to really know if it's just good acting. She did things that many of the other fake criers don't do. She grabbed a tissue. She wiped her eyes with it many times. And it might have been real tears, but I don't believe it was real tears for anyone but herself. I know that's an easy thing to say, but just look at the facts of it. And you can also see how quickly her body went from the crying to just like this cold stone look. It was also quickly switching when her ex-husband was speaking to crying to when his wife or significant other started to speaking, she switched out like that, back to the cold stone look. And then how Mr. O'Shea brought up, why would you tell those things to the teacher of what, I think she was alluding to little Walter was doing. And she just pretended, I don't have any recollection of that. And you can, this monster was, who knows what other skeletons are in her closet, but I think it's easy to take away that she was just absolutely hell-bent on controlling this little kid and making this little Walter, making his life a living hell until she took his life. A 7-year-old. She never deserves to see a day of freedom. And she you could tell at her commutation hearing, which was a wonderful thing to see, is that no one was there really, right? And you didn't have to listen to all of these people ringing her praises, and even the warden kind of I think the warden picked up on the fact that she was kind of like fake crying. The warden just kind of, "Are you done?" You know, I think that was another signal. "Are you done?" And she's just like, "Yeah, yeah." And he like just ended it. I think everyone was just disgusted. And it was the ending that, not the Hollywood ending for little Walter, but at least it wasn't a slap in the face to justice. Evil does exist, and we just saw it. I'm sorry I don't have any documents on this case. You would think that because she received life in prison, that she would have gone to trial and there would have been an appeal, but sometimes they don't appeal. Sometimes things happen in an interesting way. Sometimes they have to take a plea deal to avoid the ultimate punishment, and maybe that's what happened here. But Richard couldn't find anything. You'd think it would have made the news article, but it didn't. But I like this board. It's pretty, Mr. Roche, Ms. Fernazza, Mr. Marabella, and we don't see a lot of Victor Jones. Sometimes I appreciate him. Sometimes but we haven't seen a lot of him. But I'll do another hearing from the same date, same board, and we do have case documentation that we'll go over afterwards. So let's go jump in on this hearing.
You're Carroll Goens, DOC number 490255. You are currently serving a 30-year sentence. You were sentenced on March 17, 2005 for a manslaughter conviction out of Ouachita Parish. Is that correct?
Yes, ma'am.
All right, Mr. Roche, I'll turn it over to you.
Thank you, Madam Chairman. Good morning, Ms. Goens. How are you?
Fine. And you, sir?
I'm great. Thank you so much for asking. I'm going to do a little presentation. In the process of doing the presentation, I'll ask you a couple of questions, okay?
Yes, sir.
Just sit back and relax and we'll have a conversation, okay? Madam Chairman, before us we have Carroll P. Goens, DOC number 490255. She's here this morning seeking a recommendation for a commutation of sentence for the offense of manslaughter, which she was sentenced to 30 years at hard labor. She's currently 58 years old. At the time of the offense, she was 37. She's been incarcerated right at 21 years of the 30-year sentence. She has a good time date of March 14, 2025. And if she would max out on her good time credits, that good time date would move up to September of 2024. Ms. Goens was arrested on February 26, the year 2000, and charged with second-degree murder. She pled to manslaughter and was sentenced on March 17, 2005, some 5 years after being arrested. Ms. Goens, why did the process from arrest to conviction or when you pled take 5 years? What was going on?
Why did it take 5 years from the time you were arrested to the time you pled?
That, I don't know, sir. They just kept postponing me and just putting it off. They wouldn't never explain it to me.
So when you finally decided that you were going to do a plea deal and pled to manslaughter, they brought you to court and accepted your plea. Is that correct?
Yes, sir.
Opposition in this case comes from the sentencing judge in the 4th JDC, the District Attorney's Office in the 4th JDC, the Washita Parish Sheriff's Office, the Chief of Police of Monroe, Louisiana, and the Chief of Police of West Monroe. Opposition also comes from the victim's family. The victim's sister, Ms. Tina Kelso Manning, the victim's brother-in-law, William Manning, the victim's sister, Ms. Cynthia Rigsby Knighton, and Ms. Knighton is present here at the hearing, and she will make a statement later on during the hearing. Ms. Goens has 2 arrests on her record. She is a first felony offender. She has a low risk assessment score. She has achieved trustee level, and she's been a trustee for a number of years. Her present job is group keeper. Tell me what a group keeper does, Ms. Goens.
I do unit 2. I clean and I do chemicals and I deliver some packages. That's what I do.
So, to my understanding that you do chemical cleaning, even to the warden's home, and you deliver packages from the administration building. Is that correct?
Yes, sir.
Okay. Tell me about the programs that you've completed. Your PPI didn't have the programs. Tell me the programs that you've completed in your 21 years of incarceration.
Celebrate Recovery, CARROLL, and what's the other name? Anger management.
Okay. Tell me about the your disciplinary record. When's the last time you had my record shows that you went to Louisiana Transitional Center for Women in March of 2014. You've had no write-up since 2014. When was your last write-up?
I hadn't had one since I've been here, sir.
Okay. When was the last one you had?
Oh, that was back in 07 or 08, one of the two. It's been a long time.
So it's been 12 or 13 years since you had a disciplinary write-up. Okay, very, very good. Her institutional level is good. Custody level is medium. Tell me about the educational achievements that you've achieved in the last 21 years. You have a GED.
No, sir, I don't have a diploma on GED.
Have you taken literacy classes?
She can read and write. She can read and write well.
Okay. Ms. Bauer, how's her work evaluations?
Very well. She's a very hard worker here. Does very well.
Thank you, Ms. Bauer. And I'll get back to you later, Ms. Bauer. Tell us about your transition plan. Where do you plan to live and where do you plan to work if and when you're released?
I'm gonna help my sister that she's ill with arthritis and stuff, but I'm gonna work for her and it's a few other people. I can take care of myself and real dependable. And I'm gonna live with my sister. She lives on Caney Lake in Jackson Parish.
Okay. Now, you don't have a GED. Do you have any vocational skills that you can financially support yourself?
I can do landscaping, gardening, all different sorts of things.
I see in your record that you have some certificates or degrees in horticulture. Is that correct?
I went to horticulture, but I didn't get none.
Okay. As I said before, you only have 165 hours of good time. And regardless of the outcome today, you need to enroll in some more classes, because if you're successful today, you'll have to go through the parole process. And if you don't have any good time classes, it's going to be very difficult for a parole panel to consider you. So I would enroll in as many good time classes as possible. There's letters of opposition from William Allen Manning, a brother-in-law of the victim. We have opposition from Ms. Cynthia Knighton and Ms. Tina Manning. We have letters of support from your sister, Ms. Helen Pauline Millwood, and that's why you're going to be staying in Chatham, Louisiana. Is that correct?
Yes, sir.
Ms. Bauer, do you have any comments, remarks, or observations at this time?
She has worked very hard. The reason she hadn't had any more educational classes is due to her current release date. We have not been able to put her in any educational classes. It hadn't been due to her not wanting them. It's due to our regulations. We're not able to put her in anymore right now.
So if she was successful today, she would be in line to take the classes. Am I correct?
Yes, sir. Yes, sir. If she was granted today, that would definitely make her eligible for anything.
Okay. Madam Chairman, that completes my presentation this morning. I do have a recommendation in this case, and I will share it with you and my fellow board members at the conclusion of this interview.
Thank you, Mr. Roche. Mr. Marabella?
Yes, ma'am. Thank you, Madam Chairman. Ms. Goens, I've reviewed your record, and it appears that you indicated back when all of this happened that you had very little recollection of what happened. Is that fair to say?
Yes, sir.
Okay. Do you have any independent recollection today of what happened?
Yes, sir. And I take the blame for it, and I'm sorry about it.
Okay. Well, let me ask you a few questions about that. Mr. Roche asked you, why did it take you so long to be able to enter your plea? And I was looking through your record, and it appears that initially you had pled guilty, not guilty, and not guilty by reason of insanity. There was a sanity commission. There were hearings to determine your competency and your mental ability to know right from wrong. Did you get any treatment back then? Did you actually go to a facility, or were you evaluated? Do you remember any of that?
I was evaluated, yes, sir.
Okay, do you remember where you were evaluated at?
At Washita Correction Center.
Okay. Now, at the time this was going on, were you on drugs, or at the time of the commission of this offense, were you on drugs or alcohol at the time?
Alcohol.
Okay, and how often had you been drinking? How long have you been, was the drinking part of the reason why you couldn't remember?
Yes, sir.
You're cutting out on me. I don't know if it's just my computer that's cutting out or not. Were you drinking heavily that night?
Yes, sir.
Had you been drinking all your life before that night?
I've drank about 10 years.
Have you ever had prior to that offense any sort of mental health evaluation
Yes, sir.
before the commission of this crime?
Yes, sir.
Were you on any kind of medication for your mental health issues?
Yes, sir.
Do you know what you were on?
I can't remember. It's
Do you
been,
know why? Do you know why you initially went to a doctor for mental health issues?
depression.
Okay. Since you've been in prison, have you been evaluated? Have you taken any kind of medication for your mental health issues?
No, sir.
Okay, it was a compound question, so I'm going to ask one at a time. Have you been evaluated for any mental health issues while you've been in prison?
Yes, sir.
Okay. And even with those evaluations, no one has prescribed any medications for you?
No, sir.
Do you currently suffer from depression to your knowledge?
Mr. Mirabella, let me clarify that for her real quick.
Sure.
Okay, when you were at LCIW, did you see a counselor or anything for your mental health, for your depression or anything?
Yes.
Okay, did you take any medication? Do you know it for your depression?
My depression.
Okay, while you were at LCIW,
Yeah.
you don't take it here?
No.
Okay,
Took me off of.
okay, she did get assessed at LCIW when she was there. She was on medication for it there. She has not been on it since she's been here.
Okay. And do we know if that's because they don't think she needs it anymore, or they just didn't give it to her there?
If I had to guess, it was just, she was probably just taken off of it. Because we don't have anybody that does an assessment for mental health.
Okay. All right. Madam Chairman, I think that's all the questions I have. Thank you.
Thank you, Mr. Mirabella. Mr. Jones?
I don't have any questions this time, Madam Chairman.
Thank you. Ms. Goens, you, as I think we've established, you pled guilty to this offense. Is that correct?
Yes, ma'am.
And you have a mandatory release date, which is your good time release date, which is March 14, 2025.
Yes, ma'am.
Okay, so you will be getting out in March of 2025. What is your expectation today? Excuse me, Ms. Knight, and I'll get to you in a minute. I'll explain that date to you in a minute. So, Ms. Goens, what is your expectation for today? What are you asking this board?
You're asking to be considered for.
I'm asking to be considered for early parole.
So you want to be, you have a parole date, eligibility date rather, that is after your good time release date. So you're asking to move that forward, to move it up.
Yes, ma'am.
Okay. All right. I just wasn't clear on exactly what you were asking today. Let's hear from Ms. Knighton. Ms. Knighton, go ahead and unmute your microphone. And while you're doing that, I'll explain to you, and staff can do it after too. No matter what happens today, should she not be successful today, her release date is her good time date. And that date, as I read it, is March 14, 2025. That's not anything we have any control over. That's a mandatory release date set by law. And apparently you all victims were not made aware of that particular date. But we can let staff explain to you how that works when we finish. But we'd like to hear your input.
Yes, ma'am.
Okay.
This is the very first time I have ever met this woman, ever seen her. She has not once contacted any of our family members. She has never once shown remorse of any kind. Matter of fact, after she killed my mother, she was in jail and she was bragging how she killed my mother and she only had a lump on her head. Okay. This woman killed my mother for $50 that was in her pocket. She killed her and she stabbed her so hard in her back when she was on the ground that the knife came out through her chest. Then she walked back to her little RV with bloody clothes and my mother's bloody money. Now, I was in complete opposition about her even doing a plea bargain, but my aunt, my mother's sister, and my mother's sister's husband did not want. They actually are the ones who allowed this to happen. They didn't confront me. I was not allowed to speak in opposition, even though I was an adult. But because my brother has a history of drug use, alcoholism, the same as my mother did, they did not tell me because they didn't want him to know, because they were scared that if she got out or if anything happened, that he would go and possibly try to do something to her. But I have never once ever wanted her to be able to get out of prison. Okay. My mother was 47 years old. I am 48. My brother is 47. Since my mother has passed away, I lost my 3-year-old daughter. This year, my aunt's husband, William Manning, has died March 10th from a pulmonary embolism. He was a journalist for CBS News and then for ABC in Dallas, Texas, Fort Worth. He was an assignment editor. He was a general manager. My aunt has survived cancer. My elderly grandparents are still alive. She still needs help with them. They are in an assisted living home because she can't help them now. Can't see them because of COVID. They are confused and don't understand. They can't know about this right here that's going on today. My aunt would have been here, but I can't let her know she's not mentally stable. And the reason she's not mentally stable is because her sister was murdered and her husband died. If this woman had not taken my mother's life, my mother would be here now to help my sister with her elderly parents, to help me with her kids, my grandkids, her grandkids, and my grandkids, which are her great grandkids. She has 2. Not only that, my son died this year, okay, on July 19th. Why do I have to go through this? She was denied by the Court of Appeal of Louisiana's Second Circuit, State of Louisiana Appellate versus Carroll Potts Goens, aka Carroll Goens Appellant, decided January 25th, 2006. She was denied an appeal and her decision was affirmed. She is not allowed to get out. She pled to 30 years with no chance of parole, not even early. She is supposed to stay there until 2030. And I beg of you not to let this woman out. She has done nothing to make sure that she is going to have maybe she has a support system, but has she shown repentance? Has she shown regret? Has she changed? Has she shown true remorse? No, she's saying, I'm sorry, so she can get out early. Is she going to be a productive member of society? Please. Since you killed my mother, Ms. Goens, I have gotten
Miss
2
Knighton,
associates.
Miss Knighton, Miss Knighton, you need to address your remarks to us, not to her.
I'm so sorry.
That's okay. We
in the
appreciate your
last 30
input
years,
today.
In the last 30 years, I have gotten 2 associate's degrees, one in accounting and one in banking and finance. So there is no reason why she couldn't have had. And if Louisiana doesn't have the way for her to be rehabilitated before she's released, maybe she shouldn't be released until Louisiana changes something and allows her to be able to be on that path. My brother is 47 years old and he has been addicted to alcohol and drugs. And majority of that time that he has been in jail, he hasn't gotten the help he needs, and he is out, and he is not a productive member of society. This woman met my mother in jail. My mother wasn't addicted to crack. She purchased crack from an undercover officer. She got out in 4 months of her own recognizance, and during that time, she met Miss Goens in jail. When this woman got out of jail, shortly after, my mother got her a job at Red Roof Inn. Okay, so she's worked at a hotel before, but she was prostituting before she went into jail, and so was my mother.
Okay, can you wrap it up for us? We're running out of time, Ms. Knighton.
I do not believe she would be a productive member of society. I do not believe that she has any remorse in her heart, and I believe she should serve her full time that she signed on for.
Okay, and are you joining us from Georgia?
Yes, ma'am.
Thank you for, we do appreciate your participation today. And I'm gonna ask my colleagues for, let me ask Ms. Goens, is there a statement you'd like to make before we vote?
Yes, ma'am.
Okay, go ahead.
Okay, I, Carol Goens, am coming to you today to ask for clemency. I have been incarcerated for 20 years and 11 months for the charge of manslaughter. I have taken classes as well as learning multiple skills while incarcerated. I have completed anger management as well as Celebrate Recovery and CARROLL. I have been a trustee and have taken on multiple duties such as passing out chemicals, janitor work, and landscaping and package delivery. I have 2 sons who also have children, my grandchildren who need me. My 2 sisters are both ill. My sister Geraldine has a heart problem and a pacemaker. My sister Pauline has cerebral arthritis. If granted clemency, I will be moving in with my sister Pauline in order to assist her. I have not had any disciplinary reports throughout my entire incarceration. I have mastered and have become wiser. I have matured and have become wiser. I have learned from my mistakes and experience. I will not repeat my mistakes, and I am very responsible. I truly believe that I have been rehabilitated and ready to move forward with my life. Although I cannot take back what happened, and I know my actions have caused many people pain and hurt. I am deeply sorry and I am begging for mercy. I plead that you take all of this in consideration and grant me clemency. Thank you for both your time and consideration. May God bless all of you, Brother and Durr.
Thank you. Thank you. All right, Mr. Roche, I'm gonna turn it over back to you for your recommendation and vote.
Thank you, Madam Chairman. After going over all information that we were given and listening and conducting this interview, my recommendation is based on a substantial portion of her sentence has been served. She served approximately 70% of her sentence. She has an excellent disciplinary record, no disciplinary write-ups in 21 years. She had favorable recommendation from the facility staff, and she serves as a trustee for numerous years in the administration building of the facility. My recommendation is that we recommend to the governor that she has parole eligibility after serving 70% of her sentence.
Thank you, Mr. Roche. Mr. Marabella?
Madam Chairman, I agree with Mr. Roche. I have one qualifying comment. However, I would request that she get a mental health evaluation and determine whether or not she needs to be on medication. Otherwise, my vote would be the same as Mr. Roche for the same reasons as he's outlined.
Thank you, Mr. Marabella. Mr. Jones?
Yes, Madam Chairman, I concur with my colleagues. My vote is the same as my colleagues.
Thank you, Mr. Jones. Ms. Goens, I was moved by your statement. My position is different than my colleagues, though. My vote today would be to deny your application. You have a mandatory good time release date in 2025. We've had opposition that's been expressed by law enforcement and the victim this morning. So my vote today is to deny your application. So you've received three favorable votes, one that's not favorable. So the result of today's proceedings is that your application for clemency has been denied. Ms. Knighton, if you would, we're going to leave, but if.
Okay, I'm actually surprised. I'm surprised for a few reasons. One is I kind of thought this was a shoe-in commutation grant. It just felt that way. She pled to like a lesser charge, served most of her sentence, and this is a commutation hearing, right? So they would recommend it to the governor. It would always takes, not always, but up until recently, now they're going faster in 2023 because the governor's leaving office and he wants to push through all the commutations before he leaves. But before then, at the time of this day, 2021, you can wait quite some time before the governor would approve, and then you have the parole hearing. And because she's not allowed to take programs until her release date moves up, I thought for sure, and I think that's why the others had approved her, because they wanted her to just get in more programs to learn more instead of just sitting there and kind of rotting away, so to speak. But I think what's most surprising is again, that Ms. Renatza is the one that denied. Now they only have 4 board members, so it needs to be unanimous. When they have 5 board members, you can have a 4-to-1 vote. Why did Ms. Renatza deny? It's just kind of uncharacteristic of her. If anyone you would think would deny it would be Mr. Roche, who is the victim's advocate. Now, the things that the victim's child said in opposition, like how she was how she was never contacted by Carroll, and Carroll's not allowed to contact her. Now the other thing though that she said is how she was bragging about how she had killed her, as she killed her only over $50, and we'll go over the facts of the case to see exactly what happened. I thought really this hearing was a cop-out hearing. They just took her word for it that she didn't remember anything. They didn't pressure on it. They didn't ask her about what had happened at all. It was just, oh, you don't remember? Okay. Also, I thought what was quite odd is that the warden said she reads and writes well, and then at the end there, when she's reading the statement, which almost seems like it was written for her by a jailhouse lawyer or something, did not give me the impression that she reads and writes well. Although maybe the warden's definition of well is different than mine. Forgot to turn the lighting on. So, but why Ms. Renatza didn't and the others did, was another interesting thing that was different about this case is that the sentencing judge was opposed. It's pretty rare for the sentencing judge to be opposed. We just don't see it that often of an early release. We see it, but not that often. I wonder if that has something to do with it. But let's go into it. Facts. On February 26, 2000, the body of the victim, Tonja Rigby, was found behind a trailer park in West Monroe. The victim had been stabbed. Police followed a blood trail from the body to a trailer located in the park and saw blood at the door. Wow, there's like a blood trail is how they went straight to the door. Along the pathway, they found a knife with a 4-inch blade. A deputy knocked on the door of the trailer, but no one responded. Believing that someone could be injured inside the trailer, the deputy entered and found blood on the carpet. He found the defendant in the bathroom and she consented to search of the trailer. Money with blood stains was seized from between the mattress in the bedroom, and the police also found a black shirt stained with blood and dirt. The defendant stated that she and the victim met while incarcerated at Richland Parish Correctional Center. That's what her daughter said, and that they had worked together at the time of the crime. The defendant's brother-in-law identified the knife found as one that had been given to the defendant. A neighbor told police at approximately 9:30 or 10 p.m. on the night of the incident, he had seen a woman wearing a black shirt walking from the trail where the body was found toward the trailer park, and at that the same woman returned shortly thereafter with a flashlight. The witness did not know the woman's name, but said that she had recently moved into the trailer park. The defendant told police that she had been living in the trailer park for approximately 1 or 2 weeks. Another resident of the trailer park stated that between 9 and 10 p.m. that evening, she heard 2 women arguing near the defendant's trailer and heard a frightening scream. Defendant was arrested and charged with second-degree red rum. And I don't say that in jest. I say it because of YouTube. So basically, they heard arguing, then they heard a frightening scream. So those are the facts. So it appears she really did end her life over money, $50. It's unbelievable. And they took a plea deal, so they wouldn't have to go. Now let's see. Defendant argues that her speedy trial was denied when the state failed to bring her to trial in June 6, 2004. So in March 2000, the defendant was charged and entered a plea of not guilty. On December 4th of 2000, the defendant withdrew the plea and entered a plea of not guilty by reason of insanity, which is really the most ridiculous plea you can make. You'll never get that. The court appointed a 3-member sanity commission, which found the defendant lacked the mental capacity. Wow. So it did work? The court appointed a 3-member sanity commission, which found that the defendant lacked the mental capacity to understand the proceedings against her to assist in her defense. I just finished saying it never works. So it just makes you wonder. Okay, in October 2001, the court ordered the defendant to be committed to the custody Department of Health in the Eastern Louisiana Mental Health System. Forensic Division ordered DHH to advise the court once the defendant was able to comprehend the proceedings against her. On June 6, 2002, Dr. Mark Cullen, a psychiatrist at DHH, issued a report that the court, after examining the defendant, Dr. Cullen concluded that the defendant did not show symptoms of acute mental illness and opined that the defendant was able to understand proceedings against her and assist in her defense. We see this happen when they do. It's just, I don't understand how you have 3 professionals that say she doesn't understand, and then you have a doctor that says she does, and you just wonder. The state moved to reevaluation of the defendant's capacity, and the district court issued it in order that the same 3-member sanity commission, they ordered the same 3-member re-examine the defendant and submit its reports. On July 7th, the district court issued written reasons for judgment, finding that the defendant was competent to stand trial and ordering the proceedings to promptly resume. I think the whole thing is a joke. Whenever you have these professionals, these experts, these psychiatrists, it's like, I feel if you can take 3 experts and have the same person evaluated, you'd get 3 different evaluation reports. Like, it's also, in my opinion, arbitrary. I don't know. And always I wonder, okay, so are they really truly independent? Who's ordering the report? I don't trust any of it. And the state council had agreed that the court was making a decision based on the reports in lieu of contradictory hearing. This is another. The court noted the reports had been received by 2 of the 3 commission members. So one of the commission members simply never wrote a report. Like, hello, shouldn't you be held accountable for that? And that the state defense counsel had agreed that the court would make a decision based on reports in lieu of contradictory hearing. The court minutes show that on 5 occasions between September 22nd, 2003 and January 26th, including 3 times when the defendant was not present in court, either a motion hearing of the trial was to reset later that date. In a letter dated March 1st, 2004, defendant wrote to the court to express dissatisfaction with her counsel, lack of communication, and she requested that new counsel be assigned. I wonder how this happens as well. Someone who is low IQ, who's like, how do they have the capacity to write a letter and communicate that they're dissatisfied with their counsel? Now, maybe she's sitting there and she just tells some jailhouse lawyer, I don't like my attorney, and the jailhouse lawyer writes a letter for her in return for something. That's possible. In the third paragraph of the letter, the defendant stated that her constitutional rights to speedy trial obviously had been violated. The court sent a copy of the letter to the state defense counsel requesting information about the statute of the case. On December 9, 2004, after a number of additional continuances, the defendant pled guilty to manslaughter. So this is why they're saying she didn't have a speedy trial. 4 years. 4 years it took for her to get 3 mental health evaluations. That's just the way the system moves, huh? 4 years for 3 evaluations. Defendant argues that the court should have treated her letter as a motion to quash the indictment because she complained about the violation of her right to speedy trial. Defendant contends the cause of interruption no longer existed as of June 6, 2002. The date of Dr. Collins' report period resumed. You know what's interesting about all of this when you think about it is that when I think about it, is that it's like the state. So they find someone who's not alive from a knife wound, and they have one probably really unqualified or not that great of a witness that heard a woman scream. She gets locked up. She takes a plea deal, but then it's like 4 years later after saying she's not. If this had gone to trial, and if she had a good attorney, you might argue that she gets off because all the attorney has to do is say that she was in fear for her life and she had a low IQ and she was attacked and she used the knife and then a jury would have to decide whether they believe her. And there's like no evidence. And you think that after like 4 years, the state's probably looking at their paperwork and they see something mailed from her and they're like, oh man, we don't have anything on this case. It's like, let's just sign a deal. So they sign a deal with her. And you probably could argue she could have gotten a better deal. I'm not saying she's innocent. I'm not saying that she should have gotten a better deal. I'm just saying like this is, I don't even think they have a confession. I don't see a confession mentioned anywhere. It just seems like, contrary to the defendant's contention that all the information used to find her competent was available, the court needed to obtain the Sanity Commission's report to make a finding of the defendant's capacity to understand the proceeding. It's just a lot of... And they say July 7, 2003, the court found that the defendant was competent to resume proceedings. Thus, the case of interruption, the defendant incompetent to stand trial no longer existed. So they're saying, well, in 2003, she was found competent. So why? So the state was required to have a trial within 2 years. Now, the defendant's guilty plea was entered on December 2004 within 18 months of the date on which the cause of interruption was found to no longer exist. I wonder if she realized that 6 more months See, they would have had to have had a trial. She probably could have gotten a better deal. The cause of interruption found no longer exists. Consequently, the defendant's plea was made within the time period. Now, sentencing. The defendant contends that the district court erred in imposing an excessive sentence and in denying eligibility for diminution, I guess that means of sentence for good behavior, good time. Defendant argues that the denial of good time eligibility should be vacated because the court failed to advise her of those provisions in the plea deal. Whoever commits manslaughter shall be imprisoned or hard label for not more than 40 years. Convicted pleads guilty of a crime, which includes manslaughter, and is sentenced to imprisonment number of years. A sentence court may deny conditions. Okay. It is. I gotta tell you, to me, it is interesting. They do the manslaughter charge, but then they give her, I think the maximum or close to the not 40 years. They give her 30 years. Finds the defendant manslaughter, crime of violence, with the maximum sentence of 40 years. Defendant stated that she has spoken to counsel about the consequences of the plea deal and understood the sentencing range. Thus, the record demonstrates that the district court adequately complied with the requirements. I don't know who here, if you can put in the comment section, likes to go over these details. Not so much of the act of the crime, but the actual legal details of the appeal. But basically, she's arguing, so she made two arguments. One is that her constitutional rights were violated by not having a speedy trial, and they proved that they were not violated. And two is that the sentencing was excessive, or that she should have been allowed good time. And prior to imposing sentence, the district court reviewed pre-sentence investigation report and considered the facts of the case. The court was aware of the defendant's age, employment, and history of mental health problems as mitigating factors. The court noted that the defendant did not have any prior felony convictions and had expressed remorse. However, the court found that the defendant's use of dangerous weapons was an aggravating factor. In addition, the court noted the extensive wounds inflicted upon the victim, who suffered a lethal stab wound on the right side of the chest, at the base of her neck, and stab wounds in the chest near the left shoulder, in the back that existed through the chest. In the back that exited through the chest. Wow. Yeah, that's intense. It considered the defendant's history of alcohol abuse and mental illness. The court pointed out at various times that she had failed to follow through with recommendations for inpatient substance abuse treatment and counseling. The records support the district court's finding that the defendant was indeed in need of correctional treatment or custodial environment, and that a lesser sentence would depreciate the seriousness of the crime and provided adequate reasons to imposing of the sentence. The sentence imposes neither grossly disproportionate or serious of the offense committed, nor shocking of the sense of justice. There is no showing the district court. Well, I don't understand, because she did have good time date. Her good time date was 2025, which was 5 years early. No, so I'm confused by that. And maybe that's because of Act 122 or just a change in the law. But she, according to the records, and thank you, Richard, is still locked up. She's 61 years old. And I guess her good time date's coming up in 2 years. Yeah, and I don't understand. But the laws change so often, that could be why she has the good time date. How do you feel about this? About this hearing? I don't think, I think it's dangerous. She seems to still have kind of like the same issues, and how can you not argue that she wouldn't go and do something similar? She takes no accountability. She denies having any memory of it. From like legal perspectives, I think that, a good attorney, someone else, probably gets off with a fraction of a sentence. We've seen that. But if you don't have proper representation, these things can happen to you. But that doesn't mean that she should be getting out. You tell me. But anyways, thank you for being here for these 2 hearings. And with that, I'll let you go.